without spending much more time to introduce further, it's my pleasure, please join me in setting up and setting the stage for our panel to begin. Linda's going to go first, then Catherine, and then Ed, and then I'm going to let them talk a little bit between the three of them as much as they would like in terms of their respective presentations, and then we'll open it up for discussion. As today we get to be a somewhat smaller group, more intimate and with more room for discussion, this is, from my perspective, ideal. We can actually have a better discussion at this. So with no further ado, please join me in welcome.
Wonderful. Well, thank you, Steph, for that wonderful introduction, and thank you all for joining us. Thank you, Sam, for helping us make today happen. I'm really glad to be here. I'm going to be talking today about a kind of speculative element of my current project, which, as Steph mentioned, is about the history of oblivion. And it kind of followed on quite naturally from my first book, which is about post-Holocaust justice and prosecutions, and made me start thinking about the ends of things, and when the kind of legal system ends up folding back onto history and essentially erasing historical knowledge. And so I was trying to think about how we might get our way out of this feedback loop between law and history in which one erases the other. And it was while I was working on that someone casually mentioned to me this idea of legal oblivion, which I had never heard of before, but as was explained to me, erroneously, was in every peace treaty until the 1919 Treaty of Versailles. And so basically what I've been trying to do since then is working in legal history and political theory to figure out what actually oblivion was. It was in many peace treaties, not every peace treaty, how it operated in international law, and to understand what legal policies of oblivion entailed and what it means for us moderns, and indeed how and if it undergirds what we think of as the right to be forgotten today. And so just by way of introduction, I'll say, you know, what I've been doing is tracing all of the kind of instances where the word oblivion appears, not only in law, but also in computer science and data management. And so I was quite interested a few years ago when I came across a scientific paper that was authored by a group of computer scientists in Germany and New Zealand, where they announced they had come up with a universal framework called oblivion. And its function was rather straightforward. It could identify and de-index links from online search engines at extreme speed, handling, they said, 278 removal requests per second. They promised nothing less than to make forgetting scalable, in their terms, as seamless and widespread as possible, and their citations reference similar programs, including one called Vanish, that makes self-destructing data, and another called the Ephemerizer, which also promised to make data disappear. And so this was all in the era right after the GDPR went into force, and there was this concern with, okay, how do we make it operational? What are the kind of coding concerns that need to be in place for this to work? And so the right to be forgotten, as many of you may know, was officially called the right to erasure. It's a European right that affords individuals the ability to demand data erasure, to require criminal databases and online sources, to remove any personal data that is no longer relevant or in the public interest. And so there's two distinct but related ideas to the law. The first is that we have a right to delete the data that we leave behind as we move about the digital world, perhaps that we kind of passively leave behind us. The second is a more active right, I would say, that a right to oblivion that endows us with what the scholar Meg Lita-Jones calls informational self-determination. And it's funny, she avoids the word oblivion, which does appear in a lot of scholarship about this because of its negative connotations, because it can speak of this destructive form of erasure. And so she's come up with informational self-determination to describe it in other words. So under this category of the right, minor offenses, arrests, and dropped charges from the past may be deleted from internet articles and websites if they fit certain criteria, such as in cases where criminal records have been sealed or expunged and the penalties long ago fulfilled, or indeed when no crime was found to have been committed in the first place. sorry, yes. So one of the origins of this right to be forgotten is from the French droit à l'oubli, the right of oblivion from the 1970s, that allowed a convicted criminal who had served his time and had been rehabilitated to object to the publication of the facts of his conviction and incarceration. Can you hear me? Okay. Okay, I'll try. And so now we have similar provisions in the US. We have clean slate legislation, including newly in New York, that allows individuals to request the sealing and expungement of criminal records and the deletion of any public references to past crimes. And this is kind of an ongoing movement in the United States to get as many states as possible to sign up for similar measures. And the kind of specter of a federal right to be right to be forgotten or clean slate act kind of continuously recurs, although under current conditions, it's quite unlikely. Anyway, so that's setting the scene. My interest, I feel bear with me, is in what is the right to oblivion and from where is it derived? What is the legal tradition that backs it up? And of course, the conventional approach to this question is to point to the evolution of privacy law. Yet there's an older history that's kind of, I think, lurking behind this right and how it determines the relation between sovereign and subject. And there's this new book, The Right to Oblivion by Lowry Presley, who's at Stanford. And briefly, he mentions this much longer tradition of legal oblivion that is the current subject of my research. And these were the formal acts of oblivion that I started out by mentioning. They were structural elements of international relations and domestic political reconciliations. They were declared in the aftermath of civil wars and revolutions and were a constituent part of continental European peace treaties, most famously the Westphalian Peace Treaty. And I would suggest they're part of the frame that governs the legibility of these treaties themselves. The first act of oblivion, you might find, is said to have taken place in ancient Greece in 403 BCE, after the reign of the 30 tyrants and the democratic victory over oligarchic rule. Here, you find a package of reconciliation measures drawn up, and these included reparations, the restitution of confiscated property, trials for the tyrants themselves, as well as known murderers. All other citizens were restored to full rights, their prior misdeeds and debts obliviated. As the scholar Edwin Carolyn has documented, with a few exceptions, quote, all records of debts and misdeeds by which a citizen must be disenfranchised were to be deleted, and any privately held copy must be handed over to the officials. The slate is wiped clean, literally, end quote. Official tablets were whitewashed to erase prior misdeeds and to make room for future disputes. For Nicolereau, famous French theorist, this material erasure was a primary part of the choreography of reconciliation, but also of Athenian politics writ large. She writes, erasing, nothing but banal, run-of-the-mill political life. And this is the kind of suspicion that I'm trying to follow through. If erasing is indeed part of our political life, how is it operating? How has it always kind of structured the relationship between citizens and sovereign? And here, this episode that I'm recounting to you is said to be the first instance of transitional justice, and that's kind of how it's most often invoked. And I think that when we talk about the right to be forgotten, in some cases we are talking about that, even if on a kind of individualized level. So if you'll bear with me for a little longer, I'll just keep talking about this for a bit more, because there's a very important element of this event, which is that every person in Athens recited an oath of loyalty, promising obedience to the restored democracy. It was a paradoxical promise to always remember precisely what they had sworn to forget. They promised not to think of, to recollect, to remind themselves of evil, not to make bad use of memory, not to manipulate memory, not to use it for malign purposes or for personal gain, not to levy vengeful lawsuits or prolong the disputes of the past. Whoever took the oath swore that they would always guard this memory at the very heart of the political body. And this oath was considered to be the defining feature of the Athenian solution, the thing that bound society together. So you can think of it perhaps not as a mechanism for forgetfulness, as it is often mistakenly described, but rather as an avenue for restoring rights and properties and privileges, for getting rid of the laws that had allowed the oligarchy to function and restoring those of the democratic republic. In subsequent adaptations and interpretations of this measure, however, the emphasis on physical erasure drops out. And so what you have is it's this fascinating instance in which people continuously look back to this episode as a kind of instruction for how they are internally going to move on from periods of revolt and strife in society. And it's this recursive return that I find totally fascinating, and what is lost along the way. So the physical erasure drops out. What you are left with is legislative acts and treaty clauses that promise to restore individuals to the situations they occupied prior to the outbreak of conflict. And this is where you find promises to bury in oblivion all wrongs committed during the war. It operated as a way of resetting the historical clock, in some cases literally deleting the days from the calendar in which the restoration occurred. So it was obviously an imperial technology, a way of delimiting the putative ends of periods of seemingly anomalous strife that sought to reach the future by drawing a line over the past, by preventing vengeful lawsuits and lingering resentments. So we can talk about the theory of oblivion maybe during the Q&A, but what I, am interested in is, what does the history of oblivion reveal about our current memory environment? And of course, the reason why we're here today, the site where modern oblivion is most actively at work, I think, is the realm of computer memory, where few things are ever fully erased, and ghost and tombstone files haunt our servers long after we press delete. The European right to be forgotten has sought to ensure that erasing has returned to political life, that citizenship and the experience of subjecthood is once again defined in part by the ability to have control over the narrative of one's past. It's an individual right. So I suspect that the adoption of this new right marks another one of Oblivion's transfigurations. In this context, it's once again portrayed as having a rehabilitative function, allowing individuals to erase records and reports of bygone criminality. European nations are expanding the right so that it protects, for example, cancer survivors from facing penalties from insurance companies, banks, adoption agencies, and more because of their prior health troubles. French citizens can request numerical oblivion and the right to erase personal information from financial databases after a reasonable period of time. So what this history shows is that there are many forms of oblivion, and that the kind of erasure or deletion stipulated by the European law is not uniform. If oblivion once functioned as a mechanism for joining sovereign and subject in a shared commitment not to recall, not to verbally make mention, but not necessarily to forget, that which once divided them, here again the possibility of data erasure can readjust the relation between citizen state and non-state actors who collect and store our digital information. And the final thing I'll say by way of introduction is that one of the ways that you see this is in actually a lack of consensus about the kind of deletion that the right to be forgotten mandates. That it is essentially left to every company to determine what deletion is sufficient. And you see these debates about whether we're merely talking about soft deletion of files after a request is made, or if you have to have hard deletion, that is to say, complete erasure of any record from the database. And in some cases, that means like making a physical change. It's completely fascinating to me that we don't have a shared definition of deletion, and that this is being worked out in real time. And as an answer to this question, what you see is what began as a European right is actually being pushed back to the states and becoming a question of individual sovereignty, where you have the Denmark authority saying this is what we consider to be deletion, and we have the UK authority offering another option. And so we have a kind of fragmentation as these things are being worked out in real time. And the last thing I'll say is the Danish one, fascinatingly, has said that what you have to do is make a record of every single deletion that has ever been made, so that you can have a record of precisely how the law is being carried out. So I think that's the situation in which we find ourselves today, in which we have this right, but we don't know what it is, and we don't know what it's doing to us as subjects.
My turn.
Yes.
Thank you very much. First of all, thank you all for being here with us. Many thanks especially to the Remark Institute and especially to Professor Stefanos Geroulanos for his inspiring leadership, and to Samantha and Amy for the soul of the Institute, for their kindness, generosity, and most of all for their continuous support. Secondly, don't be afraid. What we are going to talk about is not, from my point of view, is not strictly a legal issue. The right to oblivion, as Linda has already mentioned, is more a ministry of existentialist philosophy than of classical legal issues. It's something, let's say, like the legal version of a concept very close to the historical revisionism. The right to be forgotten, the right to be oblivion, as it is is a complex and intriguing judicial instrument. It's a right, Linda has already mentioned it, of French origin or inspiration. And the core problem of the core concept concerns the questions of whether internet users should be entitled or not to erase personal information stored in the web. To begin with, it would be interesting to reflect on the affiliations of the right to oblivion with the right to data protection as a component of the right to privacy, as well as with the right to personal identity. It's the first, sorry, I forgot it. Thank you. It's the first slide. As well as with the right to personal identity. It has been supported, and I think it's right that it would be erroneous to reduce the right to oblivion exclusively to privacy, as the right to be forgotten refers to a broader conception of personal identity. The right to identity can be defined as the right to be oneself, to be different from others, to be unique in this world. In this sense, the right to oblivion enriches, in fact, the concept, as it underlines not only the right to be different from others, but also, moreover, the right to be different from oneself, namely from one's past self. This seems to be an extremely important nuance, as it reflects the fundamental perspective of the right to oblivion in enabling the deconstructions of one's identity. In other words, the right to forgotten enlarges the liberty, as it ensures the potential for almost a new beginning in one's life. Personal identity on the other hand, should not be characterized as immutable and contingent, something that one has per natura. Identity is instead a social and cultural construct, something we choose, we develop, and to which we adhere to. This approach reminds somehow of Ricoeur's conceptualization of the identity as an evolutive narrative open to revision, always open to revision. Deconstructions of one's identity allows the individual to reinvent her identity narrative, having the certainty that the past won't undermine such process. Technically speaking, the right to oblivion is broadly related with the way in which past information is currently made available online. The accelerated development of technology and communication tools, as well as the ease of access to it by means of searches linked to a person's name, can have far-reaching negative impact on how a person is perceived by the public opinion. In fact, the expansion of technology and social media made citizens extremely vulnerable vis-à-vis the internal imprint of their image. This affects, for example, individuals' perspective in the process of seeking a job or in business relations. Individuals at the mercy of their reputation may live in constant fear of being exposed, of being confronted with their past actions, or public statements or posts on social media and so on. Such an awkward, if not devastating, context may sometimes result in personal or professional disaster. So what about a solution to this complex situation? What does the rule of law can do about this? National and European legislation and jurisprudence try to manage the challenge by adopting measures, legislative measures, having as main aim to strike a fair balance between, from one side, freedom of expression and the right of the public to have access to the information, protected by the Article 10 of the European Convention, and on the other hand, the data subject's right to protection of their reputation as is enshrined in the Article 8 of the European Constitution. How does this right work in legal practice? The right to be forgotten does not create a right to have information, such as, for example, newspapers articles, removed from internet sites where the information had been initially published. Instead, it provides individuals with the right to request that search engines remove links to those sites that result when a user searches on the individual's name. For example, if an article about an individual's bankruptcy had been published in a newspaper some decades ago, the individual concerned can request that the search machine, Google or whatever, remove or delete links to that story so that the story cannot be retrieved when someone performs a search on his name. Instead, the individual cannot demand that the newspaper itself retract the story or remove it from the online archive. That means that the article is simply removed from name-based searches while it still exists on the host site. Other words, the right to be forgotten does not mean erasure of the information, literally speaking. It rather means to stop bringing data from the past. That means that the article becomes relatively obscure, but someone who knows where to look on the newspaper site, he still can retrieve it. In this framework, it's important that prospective, for example, employees or future colleagues are presumably excluded from the information, from the critical information about bankruptcy. This also may be the case equally as regards the criminal past of an individual. Supposing that this individual has already received a rehabilitation decision from the court, that means that according to the law, the crime, the conviction had been cleared from his record. In this case, the impact of an internal online archive would nullify practically the provision of the law. Let's see some decisions of the European Court concerning this right. For example, during the election, the first one dated from 2022, during the elections for the office of Federal President of Austria, a daily newspaper was ordered to refrain from publishing a photograph of the brother of the candidate's office manager. That person was called a convicted neo-Nazi, and moreover, in the accompanying text, his conviction and release from prison dated from many years before the publication of the photo in question, while the conviction had meanwhile been deleted from his criminal record. The media owner of a newspaper complained to the European Court of a violation of its freedom to impart information. The court, however, found no violation of Article 10, having regard to a number of factors including that the article had not really concerned a public person, meaning that it was not about the candidate's office manager himself, but only about his brother. The text accompanying the contested photograph had lacked the information that it was not updated, that the person in question had meanwhile served his sentence and had behaved well since then, so it was correct, but not complete. And finally, the court took in consideration that many years had passed from the conviction in questions. Another relatively recent decision concerns, two lawyers requested the removal of a newspaper article still accessible to the public on the newspaper's website, as the article in question alleged that the applicants had made a fortune by assisting politicians in dubious business deals. The lawyers complained that it was damaging to their reputation. The court held that the internet, which is an information and communication tool particularly distinct from the print media, serving billions of users worldwide, is not and potentially would never be subject to the same regulations and control as the traditional media. Therefore, the policies governing the reproduction of material from the print media and the internet might differ. The rules concerning internet undeniably had to be adjusted according to the specific features of technology in order to secure the protection and promotion of individual rights. So in this case, the court emphasized that the applicant could probably seek to secure the effective protection of his right, but in less intrusive measures than the removal of the article from the online archive. Another decision dated from 2017 concerned an article in the online edition of the New York Times concerning a German international businessman about his involvement in gold smuggling and embezzlement and of having links to Russian organized crime. The German courts rejected the request of the internationally active entrepreneur for an injunction against certain statements about him in the article published in the online edition of the New York Times. The European Court, from his point of view, found that the German court has struck a reasonable balance between the applicant's right to respect for his private life, because for a variety of reasons. First of all, because the article in question had contributed to a debate of public interest. There had been, I'm not sure, but I think that this person related in media business, so it was a matter of public interest. Also, that there had been a certain interest in the article since the applicant was a German, yeah, it's true, a businessman, internationally active in the media sector. Thirdly, that the article had a sufficient factual basis. The journalist had complied fully with journalistic duties and deontology and responsibilities. The article had been free from polemical statements and insinuations, and the information disseminated had mainly concerned the applicant's professional life. So in this case, the court found there was no violation of Articles 8 and the right to privacy and right to freedom of expression. Another decision against versus Belgium concerned the publisher of a Belgian daily newspaper was ordered to anonymize the electronic online version of an article originally published in 1994 in the print edition of the newspaper, which mentioned the full name of the driver responsible for a fatal road traffic accident in 1994. In assessing whether the contested measure was necessary in a democratic society, the European Court considered that the article had no topical, historical, or scientific interest. The person claiming entitlement to be forgotten was not well known. He was not a public person. His conduct since the event was totally in accordance with the law. The serious harm suffered by this person as a result of the continued online availability of the article with unrestricted access was apt to create, it's a very good expression, the wording, I liked it very much, a virtual criminal record. Especially in view of the length of time that had elapsed since the original publication of the article, that person could exercise his right to oblivion without having a violation of the Article 10 of the European Convention. Let's keep it, it's already known. And finally, a very recent Dutch case where a Dutch surgeon, a Dutch doctor, disciplined from her for her medical negligence, has won a legal action to remove Google search results about her case. The original suspension was later reduced to a conditional suspension on appeal, but the outdated information was still present in Google's search results. At issue were links to a website that contained an unofficial blacklist of suspended doctors. So the Dutch surgeon in question previously had her medical registration suspended, but this was later changed to a conditional suspension. So the Dutch court found that she could exercise her right to oblivion. Thank you very much. It was some only cases, and we could discuss further if you want next. Thank you very much. Thank you all.
Okay, I want to talk a bit about what I think are some of the threats, but also opportunities that emerge out of Trump administration and recent geopolitical mess that has emerged out of the tariffs, as well as the ascendance of Silicon Valley's reactionary right, as well as the ascendance of China and specific frontiers of the global tech economy, to try and chart a course that leaves some space for technological sovereignty that might allow for experiments about what other forms of digital agency we have are interested in pursuing that are not as committed to consumer protection, that are commodity regimes, or looking at data as a commodity, or focusing on rights regimes that are building up on other frameworks that are at threat. So I want to talk a little bit about why I think the current moment matters in terms of thinking through what data and privacy laws can or can't be, and then talk a little bit about some possibilities I think that emerge, maybe as like aspirational strategies, even though I guess they're unlikely to happen. I think that, so there are three things that I think are, part of this crisis and opportunity. The first is, the Trump administration's, I think, commitment to realization that some sort of re-engagement or, re-legitimization of American primacy is going to come at the cost of institutional pillars that have, supported it over the past few decades. And that this is willing to threaten its relationship with longtime partners and allies, opens an opportunity for those same countries to talk with each other about building blocs and coalitions that cut out the United States. I think that this is especially important as Silicon Valley has, kind of ascended to new heights in dominating America's state apparatus. There's a long relationship between Silicon Valley and centers of power in the American state, specifically with the military-industrial complex, but it has not been with individuals, financiers, and groups that are as committed to reactionary, anti-human philosophies, where they're hoping to re-legitimize natural forms of hierarchy along racial lines primarily. And so I think that the ascendance of this group of reactionaries is a fundamental threat to not just the United States, but to the world more broadly, as these people try to build larger coalitions and blocs of similarly minded right-wing extremists or fascists, as Elon Musk has been doing in trying to intervene in the political landscapes in Britain, and in Germany as well, and will almost certainly do so in more of Europe in the years to come. And I think there's, the third plank is that there's an opportunity here in that with the threat of with the ongoing Cold War, but a threat of a, more intensified trade war between the United States and China that has brought in a bunch of other countries as casualties, there's a chance here to maybe build some sort of tech-oriented coalitions and blocs and consortiums that could give Europe a chance to play the United States and China off one another to build connections in the global South. And I think that all of these are necessary to consider, because if we're interested in figuring out what kind of role people should have, or, what, to what extent you should be able to exist in digital spaces, to what extent your life should be mediated by digital technologies, is increasingly seems like going to be dominated by or decided by a sector of the American capitalist class that is increasingly interested in figuring out how to re-legitimize these old forms of hierarchy and domination that would clear away, relatively new but ambitious efforts at preserving or inventing rights and protections for people when it comes to data and privacy. So I think I wanted to start with, and on the second plank of this, I think an inspiration for this came to me as a book talk that I went to that kind of looked at how we can address climate change through these three large strategies that mesh with each other, which is, market craft, or figuring out how can we use tools or the state apparatus to design markets, to take things off of markets, to force certain outcomes that we're interested in, to subsidize losses, or to push through industrial policy plans and goals. Public power, which is how can we then subsidize or operate publicly certain ventures and enterprises for other goals beyond profit seeking or maximization of returns. And then the third one being, communism, but I'm going to mainly focus on the first two, since the third one feels so remote, especially when we're talking about how to respond to the ascendance in part of fascists in Silicon Valley and the threat that they pose to data and privacy laws, I think. So I'll focus on these first two, this market craft and public power, and then try to maybe expand the POVs if there's time for it. And so I think, the first one, I want to use it as a chance to kind of think of like what strategies are we just not interested, or maybe not talking about, or not interested in pursuing, and what would they allow, what room would they allow for redefining what relationship people should have or can have with digital technologies, and the role that they should play in structuring their lives. With market craft, the idea here is, how is it that you can reconfigure global tech markets in Europe's favor, or in the favor of some coalition that Europe is a part of? Can you use tariffs? Can you use subsidies? Can you use regulatory coercion to force competition and its outcomes to more adhere closely to the interests of the European Union? Can you use the geopolitical chaos as a lever to try to pry open space for European firms? One example with the tariffs, is it possible to, impose asymmetrical digital tariffs on American tech firms, such as Apple and Google, while exempting European competitors and using those funds that are generated to reinvest them into domestic industry, or to subsidize the expansion of industrial capacity, productive capacity in Europe? Is it possible to leverage the tariffs that are targeting specific sectors like automobiles to make targeted attacks on, for example, Tesla's Berlin Gigafactory, and mandating that a significant part of the electric vehicle tech stack is going to be sourced through European developed firms, or risk export bans or threaten collaboration with Chinese firms in this space as well? Can data be used as a trade web you know, kind of the EU, if it, for example, goes down the route of committing to data as a commodity and thinking through property regimes or property rights that come with data as a commodity, is there a way to meter out access and charge US firms a fee based on how much EU data they're processing? And tie that maybe to transparency of the algorithms that are being offered, or the extent to which they're sharing or transferring tech that relies on data generated and accumulated and produced in the European Union. Is there a way to pursue the creation of pan-European data exchanges where startups, if we are going to keep startups as a model, and are startups going to be able to freely exchange data sets that they're using to train their models, and allow this as a way to compete with or bootstrap or bolster the development in areas where they're outpaced by the United States or by China. And similarly, is there interest in working more closely with China by offering Huawei or SMIC preferential access to EU markets in exchange for licensing for 5G or certain chip patents? Is there room for maybe a sort of insurance fund that helps protect firms that might face sanctions because they're cooperating with or working with Chinese firms, as a way to help accelerate the decoupling of United States from Silicon Valley? I think one example, or maybe two examples, is trying to use forced share buybacks to nationalize firms in the sector, or trying to seize, or well, we'll talk more about that in the next part, but potentially trying to seize firms themselves or their infrastructure or the computational infrastructure as part of an effort to try to develop a more inward industrial policy that crowds out and pushes out and is hostile to Silicon Valley. Is there room for figuring out alternatives to App Store arrangements that allow for revenue to be cleaved off if it's generated in the European Union and redirected into public funds that again can finance, support, and subsidize the creation of open source or alternatives that again are ceding the ground or stealing more ground from Silicon Valley firms and from models that they might be able to use to push out European competitors. And I think on the public power, plank, which is essentially a sort of democratic, socialism, where you use the state as a battering ram to break some of the formations or some of the groups that we're not interested in, so that we can have some space to think about alternative frameworks for digital agency. How can we use state capacity to decommodify critical tech infrastructure? How can we use it to seize or to take control of data centers, cloud computational infrastructure, algorithms, training sets, and the models, data, the compute that is necessary for the private operation of the digital economy, but that we need to figure out a way to liberate from private corporate actors if we're interested in pursuing other values as organizing principles for technological infrastructure and for the digital economy. I think that using the kind of threat of a global trade war, of using the deregulatory chaos, of using the ascendance of Silicon Valley and its commitment to privatizing larger swaths of public life, to instituting surveillance in deeper and deeper parts of daily interactions and daily life. These are opportunities for trying to pitch public ownership and democratic oversight, and trying to use these again as organizing principles for alternative ways of thinking. How should the digital world and people who use it interact? And again, here proposals might include something like creating a European, cloud authority that expropriates hyperscale data centers on EU soil, mixing public ownership and worker cooperatives, in levying high fees and fines on U.S. firms for past GDPR violations, launching state-owned and federated social media platforms that ban targeted ads and prioritize public service content, and figure out ways to integrate this with participatory budgeting tools. Working on trying to build out sort of sovereign compute command economy that integrates, market design, but also public ownership to, break up monopolies, but also to take a hostile position towards United States, specifically Silicon Valley firms in various markets. For, is there interest in forcing sort of a redistribution of compute, whether that's GPU capacity that's used to train AI clusters privately? Can that be, is there a way to mandate a redistribution of that compute time towards public use? Maybe at first through emergencies and then using it as precedent to expand that further to normalize it. Is there a way to create, algorithmic review boards or other forms or structures that are a bit more militant about ensuring there's transparency about algorithms in which they're and where they're deployed, and also allowing the ability to outright roll them back or ban them from being instituted in various places, whether that's facial recognition, whether that's welfare fraud detection, whether that is public security. I mean, figuring out ways to intervene at the level of a lot of these deployments, because they're privately done, or they're usually done through private-public partnerships with some sort of citizen board would be an interesting, I guess, aspirational goal. And, is there a way to also develop a public tech stack? Whether that's a state-owned suite of APIs that we can use for identity, for payments, for data storage, that would be as part of a larger struggle to undercut and undermine American variants, whether that's Apple Pay or Google Sign-In. And, I think some provocative examples might be, what would it take to seize Meta's Dublin headquarters, where it runs its EU data operations, and if there are legal instruments that be able to do that, or if there's a way to build towards something as aggressive as that in some other area. And what would you replace it with? Would you, or if you're interested in seizing infrastructure, is there a vision for what would replace a private infrastructure? Will there be public content moderation hub? Is there going to be some sort of public social media platform that's going to be there? It's going to be just a public hub for compute. What would replace the private infrastructure that needs to be seized and requisitioned for public good? And I think then, how much time do I have? Maybe like 5 more minutes. I think then I want to kind of hone back in on this kind of public power, because I do think that even though a lot of these proposals are, unlikely to happen in the immediacy, thinking about what is, what is it that we're interested in, what is it that we want, and how does it connect to what kind of, digital agency we're interested in pursuing is necessary as, things going along and all things continuing without much rocking of the boat. I'm skeptical of the idea that most of the rights that we are interested in are going to be a permanent feature of the international legal order, both again because of the threat that the United States poses, and because even if it does not pose a present or near-term threat, the ascendants of these groups are fundamentally hostile to legal arrangements that curb their ability to institute pervasive and universal surveillance, remote control and discipline, projection of violence and force. And this is part of why this group has not only taking the commanding heights of the economy and not only taking control of the state apparatus, but is working even more tightly with the military industrial complex in the United States. So how is it that we can get to the point where expropriation, and the confiscation of cloud infrastructure, forcing open source or the subsidizing and the expansion of open source infrastructure, and defying or ignoring extraterritorial laws is a reality? How is it that we can undermine Silicon Valley's innovation model, which is pronged on venture capital, increasingly Wall Street, worker exploitation and weak labor laws and monopolies that have safe haven in the United States? What are the moves that can be made, either in Europe itself or in conjunction with actors in the global South, to make the continent as hostile to that as possible? Whether that's targeting patents, specific firms, whether that's bolstering labor rights, whether that's figuring out a way to cripple venture capital as much as possible by imposing windfall taxes, for example, on profits. And how is it that antitrust power, anti-monopoly power can be weaponized, frankly, to in conjunction with other countries or with trials that are going on in the United States, to undermine or to break up or to outright ban startups that are entering various markets into the European Union, again, as part of a larger strategy of insulating the continent from the corrosive influence of these right-wing extremists, and also for experimenting with public ownership and space to experiment with and find new values for organizing what our digital commons should look like.
Thank you. Okay, that was a fairly rapid end. I had like lots of questions from there, but can I want to rethink that for another second before saying something, but can I ask Linda and Catherine, can you talk to each other a little bit between your two presentations? Linda, you were more on the conceptual stage and like sort of longer historical scenario, but with Catherine's detail, I'd like to see what how your two papers sort of work together. That was the first little thought here. And the second, like, I have a couple of questions that are half formulated, but perceiving a trade war as a data trade war is something that I've not was not seeing quite yet. So thank you so much for actually bringing this up to as a starting point. Why don't we try with the two of you, then if you want to bring it into this discussion?
Yeah. No, I mean, I appreciated how in your presentation you brought our attention to precisely how the right to oblivion is actually being worked out through the jurisprudence, and how, because there is this uncertainty, I think, about what it is and what is the content of the right. Yeah.
What is the content of the right? It's true that as it is a very new, a very modern right, the content of this right has not yet, and in my opinion, it won't ever be absolutely crystallized. It's case per case. That's what that's why the jurisprudence of the courts plays an essential role in delimiting this right. You know, in law there are no absolute protection of individual rights. We should always have in mind that from one side there is a right, there is a consecration, there is enshrinement of the right in the constitutional legislative text, but from the other hand, we should never forget that there are cases that we should impose an exception of the protection rule. In this case, this is the court which will go to define exactly in when the right should be limited or should not. For example, is it about a public person or not? When for example, a politician, when wants to exercise his right to oblivion, the criteria adopted by the court won't be the same if a non-named doctor from a small town wants to name from the online archive. It's different cases, so this is why the case per case exam by the courts defines the content of the.
Yeah, I mean,
And besides that, I'd like to adjust that as we have to do with evolutive technologies, the right must be updated. So the courts, the role is from this side is very important.
yeah. I mean, you say it's a modern right, I say it's an ancient right. You know, they have kind of,
An ancient, no, you're right. It's an ancient idea, an ancient concept, but his legal concentration is, you are right.
right.
You refer to the Athenian democracy.
Yeah.
You're right. The idea, the philosophical idea is nothing, of course.
Right. Yeah. No, I went to Athens last year actually looking for the altar of oblivion that, you know, no one had ever found.
And what in the
I went to see the archaeologists at the Acropolis Museum. They, you know, it was very funny, but they humored me. But I thought it was, I also think the point that it's an existential question about freedom from oneself, right? And I actually think there's something very interesting, which is partly why I find this to be so fascinating about what subjecthood entails and what it means to have this kind of infinite capacity for data retention. And I think this also kind of touches on what you were talking about the possibility of data being weaponized, and what that would mean, and whether that would actually, how that would, like, I'm curious how that would impact what we think of as the right to privacy, right? And how that would evolve. So, yeah. I mean, I think it's very rare that you have, perhaps not, but you have something that's unclear even to the people who came up with the term, that deletion is such an unstable category and is becoming even more unstable, I would say, by the day. I think there's a lot of commonalities actually between what everyone discussed. Yeah.
May I ask you something? You refer to the hard and soft erasure.
Yeah.
Yeah. Do you think that are there sufficient clear criteria so as we can distinguish between hard and soft erasure?
Yeah. I mean, soft erasure, I mean, maybe there's people in the room who are more familiar with this, but soft erasure, from what I understand, is that you delete only the surface level of the profile, but you retain the ability to restore it. Because the concern is, okay, what if someone makes a deletion request and then they change their mind? And then, you know, so the question is, do you convey it to them that this is irrecoverable? In which case that would be a hard delete. There would be no restoration. A soft delete is privileged by coders because it breaks less. It allows the technology to continue working, and what you put in is a kind of filler that it's so interesting. It retains a lot of the data, but in anonymized form, and that has been what has been kind of permissible under GDPR. And then there's the question, okay, if that's anonymized data, is that no longer protected? And that has been kind of the consensus. And there, you know, I don't know if that's correct. I don't know if that follows on how we're thinking about the protection of personal data. But yeah, a hard delete would be complete irrecoverability.
It's an interesting distinction.
Yeah. And like the developers always say, when you get a GDPR request, you have 30 days to respond, but it's very difficult. They say it's very, very difficult to do it. And there's this debate about how difficult it actually is. And of course, there's the preference for always retaining data at all times. Yeah.
Oh, I'd like also to ask you, from your point of view, do you think that big companies, big five, who have to make decisions on this, are they competent enough? Do they have elaborated secure criteria on this? Because according to me, I don't mention anything special, but it's rather obscure. The courts, there is a jurisprudence, this is published, there are some criteria, there are some scholars who work constantly on this, so we have an idea. It's no matter if we agree or we don't agree, but we more or less understand how the procedure goes. As to the five big four, there is something very obscure. How about you? What do you think from the technical point of view?
I mean, I think, a lot of a lot of the tech firms also do weaponize incompetence, or I mean, it is one thing. I think a lot of them might operate on a cynical level, understanding the areas in which the fine is less than what you have to gain, or the legal cost or the battle is less than what you have to gain if you just ignore the law. And I mean, this sort of strategy has been very successful, at least in the United States, where you really just move ahead and just do the thing you want to do. And eventually, if you build enough of connections with investors, or a large enough market share, or a large enough presence in public life, and the daily rhythms of maybe how a city operates or how some public infrastructure operates, you can evade the regulation and be able to write it yourself and integrate yourself there. So, I mean, in some ways, there's cynicism that motivates them to just act as they do. But I think also, yeah, you can weaponize the incompetence because you don't really have to.
So there's a question of accountability.
Yeah.
Well, there was over $1 billion GDPR fine for Meta, I think last year, that kind of didn't matter,
Yeah.
I mean, there have been, and there, there's these continuous pushes to enforce it, and I don't think the monetary fines have had really any effect.
So basically, isn't there a kind of like almost an intense distinction between, let's say, a kind of digital power agency that you're largely advocating for, and the sense that, like, well, obviously the court is like nowhere near that sense. The really cynical version is that the EU is kind of incapable of regulating, is very good at talking about regulating things and then pissing everybody off who acts as though their lives are like micromanaged at every possible last point, but they don't actually regulate nearly as much as they claim to do. It's kind of fascinating to imagine that they would be capable of running like material that sort of runs, let's say data that runs so much faster. So I'm fascinated about the idea of a kind of form of digital control or a form of digital management capable of managing both, let's say, the, actual infrastructure of things, and then a relation back to, what would qualify, whether at the individual or at the corporate level, as data protection, data management, let's say, privileging of domestic, quote unquote, domestic, as opposed to non-European. Do you think that this is basically what China is so effective at by comparison to others? Is that the idea?
Yeah, I mean, I think that, that does hit on it, where it's like, I think the capitalist model coming out of the United States for how we manage technological innovation, it's not going to work outside of the United States, because the United States has a bunch of benefits that aren't replicable. The state capitalist model that comes out of China is more readily replicable by entities. I mean, it is a little bit easier, especially if there's strategic partnerships with China or with other countries, to try and replicate some of this success at protecting your interior market and strictly organizing goals towards development or industrial policy, more so than what the United States has, which is the global hegemon, reserve currency, center of financial capital, huge complicated systems and regimes that allow for billions and billions and billions and tens of billions and hundreds of billions and trillions of dollars to be invested over and over into various speculative frontiers or ventures that eventually pay out. And then also just like a massive military that allows it to subsidize technological innovation and discovery in a way that Europe's never gonna be able to compete with. But if, you know, if it partners with the alternative state capitalist model, I think there's, or, you know, leverages it as part of some larger attempt to wean itself off, you know, decouple from Silicon Valley without becoming just as dependent. I think there's an opportunity there.
Let me
Well,
hold,
that's
because I
all.
have at least
Yeah.
5 questions. So Ainan, Stuart, and Stephen. I've had CJ in the back, and then, yeah. So Ainan, go ahead.
Thanks so much to the panelists. I'm Ainan. I'm a fellow this semester at the Mark as well. So I have a question, mostly for Linda, but maybe also for the other people about this, the nature of what is to be honor erased and so from the Athenian and then the 1970s French version to the shift of data in our present age, there seems to be the thing to be erased is something criminal to something that is just informational in general. What did that say about the nature of information, how it had the potential to be criminal? And what you think that says about like sort of deviant relationships between the normal and the pathological, and sort of how information itself has this criminal potential in our age or not, because then Catherine's examples were all about past crimes. And so I'm curious about like what that tension is. And you also mentioned these cancer cases for insurance. So yeah, so how much really is it about criminality or not? Or is it about identity and sort of self?
Totally. No, I mean, I think the problem is that a lot of this discussion, and I think one of the reasons why it's so wonderful to have a panel like this, is that the discussion about the right to be forgotten is often, and when I started talking to people about this, they were like, why are you interested in this? This is about privacy. This is not about justice. This is not about like data protection. Like these are totally different areas. And you're coming at it, and I, as I explained, I was coming at it from this background of looking at trials in criminal justice. And I had to really explain to people that these were very imbricated questions and processes. And I think one of the reasons they've like been kind of developing without being in conversation with one another. But when you talk to engineers, one of the things that I asked them, I was like, is this lens inappropriate to bring to it? And no, they said it's all about giving people the right to have freedom from their past selves, right? To have the ability to present themselves, not predetermined necessarily by whoever they were in the past, right? To have some kind of freedom of expression. I think because you could hypothesize about why it always presents, or at least it has in the rulings that we have so far in terms of equality, maybe because we live in a very legalistic society. I don't know. And because law always provides this like concrete frame with which to think through these problems. But I think there's an opportunity, at least for me, to think about not only, you know, in computer science and data management, they have a totally different approach to thinking about memory than we might have in these. And I think they can learn from it, because in both instances, you are making determinations about literally what memory is, what its material consists of, and where it ends, and how it is preserved, and where it is not preserved. And so I tried to learn about the process of memory allocation, which is like a computing term, which was totally fascinating for me, and that you have to have memory blocks, and you have to maintain them in a particular way to avoid memory leaks. And so basically, I think your question is so apt, because all of these disciplines are looking at the same problems from different angles. And because we do live in this moment now, kind of data we don't know weaponized against us, like taking the most dark view, but we also just want the ability to have control over our narrative, you know? So yeah, I think that's definitely part of it.
This is most to Linda and Catherine. I'm thinking about when there's a clash between rights, so a kind of right to privacy or right to be forgotten, freedom of information, right to know about information told about you, or a public interest defense, or a future historian thinking about when the secret police files were opened up in post countries, people wanted to see the information that was held on them. There was information in there about who might have been informed. Or in the FBI files, if you do a freedom of information request, they come back with so much redacted in it. So there's a clash there between a different set of rights about information. And you protect the informer or the person that has been informed on. Somebody say that they have a right to be forgotten as an informer, and the clash that might have with the person who wants. So I'm just thinking through that and whether either of you have any.
I did wonder if you actually might add a little bit, given that you know the other contexts and through your earlier book and the question
Yeah.
of questions both of falsification of information and of just like the Latin American and American model of like, no, we never did anything. No, I was never involved, so I'm not
Right.
aware. You know,
Yeah.
where the disappeared is no longer just something that happened in the past. Let's put it that way.
Yeah, I mean, and exactly like what a lot of these conversations. And precisely what do you do for the laws of oblivion? Which is so interesting because at least in the Argentinian case, there was, like, it did conform to the Athenian model or whatever has been passed down to us in that there were trials at the beginning. And then they said after a certain point, of course, then it later. But it was this kind of first attempt at transition. And I think like this, you can make all these exceptions. You can say, oh, these people were accepted from the rule and these people still prosecuted and others didn't. But what you're seeing is this impossible problem, right? Is that you cannot have universal prosecution, nor can you have universal amnesty, right? Both are catastrophic outcomes. And so the question is, how do you instrumentalize law in such a way that it, doesn't allow the conflict to reopen? And I strongly suspect that that's some version of what we see playing out. Right? How much do we want the past to determine the future? How much do former criminals have to be, like, how much time do they have to serve? And it's not a question with an answer,
In my opinion, it's really difficult to elaborate on a scientific level an impeccable theory on. The problem is it's not about it's not only legal. What it is at stake, what it is at stake in this. But our culture, how we approach our past, our memories, and what dimensions of this whole story needs to be needs to exist for the present and for the future. It's people say that it's also a theological. So when we have to decide from the point of law, from a legal point, we should be very concrete and decide on what is really necessary for the law, for our living in society. And no.
Yeah, and I'll just say, like, part of my interest in that relatedly is not only when we think about the morality of conflict, right? Like, how long do we, but also, where does law fail? Like, when does it cease to become the correct avenue in which to punish informers? And how do we know it?
In other words, that's the ration of criminal record. There is criminal record, the convictions remains there for a certain period of time. It's not the same for a major or for a minor crime. So
First, there's a whole weaponization of opinion at the same time. Issue.
Right.
So, which isn't necessarily a legal issue or not
Right.
a
It's a
priori a
culture.
legal issue, but it's a culture issue. Okay, I'm going to take 3 questions and go. So, Stephen, if that's okay, so that we.
Yeah, my name's Steve Milder. I'm also a fellow here this semester, and thanks for all the interesting talks. my question follows a little bit on what Ainan and Steph already asked, but I guess I'm really interested in the connection between the three different presentations, and it seems, because I also see this, I mean, I live in Germany, and like, it seems to me that a lot of the reason people are interested in the data protection laws has to do with like very, very personal matters. So, you know, like what platform are we going to use to communicate about our children? We're all in kindergarten together and things like that. People get very excited about that issue, and I'm wondering about the connection between that and like the bigger picture. And that's where I was also thinking a lot about how Europe comes into this conversation, because it seems like Europe has, in a way, like done quite a good job on giving this guise of regulating these things, but it hasn't seemed to do so in a way that suggests that it presents much of an alternative to the United States or anything else. And I was wondering, what is the value in seeing Europe as such an alternative? Like, is that useful, or why do we need that? And like, are there other kinds of alternatives to imagine? And so basically, if something having to do with Europe is at the center of connecting these two perspectives on the same.
Yes, no, I think my focus is.
Hold on, my bad. Why don't you go ahead, and then I'll get 3 questions onto that. Go ahead. This was a big enough question that it's.
My interest in Europe was, you know, like I was saying, all things stay the same. I really do believe that rules, our technological sector, are going to be determined by or reactionary individuals who believe things that I think are incompatible with some of the rights and concepts we're talking about here, who believe it's history, who are interested in pursuing artificial intelligence in such a way that that pervasive surveillance is not just a product offered, but an input to help scale up certain AI-powered products. And that tools, ideas motivating the design of these tools, whether that's remote control or surveillance, vision, detection of violence, organizing principles, design for the markets, for the legal code, for the philosophies, the political structures that emerge around that. And so I think in Europe here is to say that there is, midst of this, the developing crisis, I think a unique opportunity to exploit cracks that are emerging. That really the only real regions in the world that I think have at least the start and a buildup of some infrastructure and capital that are capable of working together to and then bring in other actors. Europe, working with other countries in the global south, but a strategy that's focused solely on China is harder. I think it has to be, how is it that Europe can actually develop an alternative? Use this moment to try to not just an alternative that is for data and privacy laws, but also that introduces obstacles as part of like as a future political order settlement that get in the way of this sort of crisis emerging again, where you have concentrated group, well-connected and reactionary financiers steering the direction of how technology is developed, what principles and values are motivating its design, how it's going to be deployed, who owns it, who profits from it, what that effects of that trickling down in sort of the rights that we get to enjoy, freedoms that we're interested in, or the political imaginations or the cultural imaginations that we have entertaining, whether what projects, what politics we can.
Well, I actually wanted to talk about this too myself, to ask you about this. or to say that thank you for being so optimistic about Europe. But Europe doesn't have I believe, doesn't have the will at all to oppose to Trump or to anybody for that matter. Well, they're so poor in Europe right now. You see what's happening in Europe. Every country is really following Trump's example. So I don't see how Europe can do anything like that. It gave me a hope, and I thank you for this. But I really don't see what can happen in Europe after all. But it is actually good to have people like you thinking about how we can get out of there. And so I don't want to ask you anything really. I just want to say, really, you believe in this? So it's quite something though, to hear you say that. The other thing I wanted to say in regard to other two talks a little bit, I understand and I totally agree with you that the law is murky, it's never clear. I understand that's how we live our lives with these laws. But really, can it be that the law decides whether the person is public or not public about something like that, for example?
No, it is not defined by law, but the general data protection defines some criteria concerning the impact, the importance of an erasure. So it does that when you are a public person and when you are, for example, somebody who are elected, it is important for those who are going to decide if you can serve in an office your past, more than for comparing this case to someone else who has a limited circle of persons. So it derives from the law criteria. It's not expressed. That's always like this. You can have the law must be flexible. So there cannot be strict word and not change.
But what about the Canary Mission, for example? Yeah, no. Canary Mission.
Can I follow up?
The Canary Mission, for example. Does it
Canary
matter
Mission.
if you are a public person or not a public person? I mean, you know what I'm saying.
What do you mean? If person mentioned in Canary Mission,
Yeah.
no, Canary Mission is something horrible. It's not it's not illegal to Canary Mission.
But in a court, for example, you know what I'm saying, whether you are a public person or a public person
Of
or
course,
not.
Canary Mission doesn't exert criteria. No, for God's sake, no.
Okay.
It follows on, actually. Thank you to all three of you. I have a,
Olga, sorry, just to say,
okay, sorry.
if we were in Europe, I think that the Canary Mission would be
Closed.
defamation. Yeah, it's
Would
not
be
a criteria.
closed.
Sorry for interrupting.
Thank you to all three of you. I have a general question about how we understand the digital economy. And is it so different from how we understand a classical economy? And is it such an aberration, and is it part of its singularity, that everything that Edward, I think, mentioned is in many ways part of classical liberalism, Keynesian with a little L? You know, regulation, control the monopolies. These are things that many countries are already living with or have lived with until Reagan and Thatcher. They're not unknown. So I think part of the way, and we get it, I mean, in our everyday life as well as humanities people, part of the way that Silicon Valley presents itself is as a singular aberration, as a unique phenomenon. That's part of the United States, blah, all of that. And somehow it puts us in the position to try and come up with new theories of economy to understand it. So my question is, the European, the global South, the Latin American experience, is there nothing else we can draw on that might be a little bit more complex, can account for a little bit of the ambiguity? There's a genealogy in this ambiguity in the law. We haven't discussed, you know, Catherine and Linda's, you know what I mean? This isn't new. What I'm saying is there a tradition that we can tap into of political economy without somewhat falling into this mythology of Silicon Valley that everything has to be ab initio. We have, you know, everything is clean slate. We have to start again, think again, which is sometimes part of end of the, you know, end times thinking.
I'm conscious of time. So CJ, last question.
CJ, history postdoc. I was wondering, to piggyback a little bit off of Stuart's question about the tension between the right of being forgotten versus freedom of information. I was wondering how each of you is thinking about the challenges of data interconnectivity when a person's data does not necessarily pertain to themselves, but also pertains to other individuals, with things like Ancestry.com and the 23andMe, which of course their entire database got bought out, where one person's choice, even to opt into a certain data regime, compromises other people's ability to choose whether or not to participate in it. And perhaps this also ties into the larger question of weaponization, of a commodification of data, as we see with these ginormous genetic databases that China's data surveillance state has generated of the minority population.
Yeah, to your point, I believe Europe's going to do any of this, of course. But I think it's interesting to ask, like, okay, what are the things we want? Why aren't we able to get them? Does that shed any light into fundamental limitations on what political programs we can pursue that open up opportunities that we didn't consider before? So my interest is more so in trying to articulate. I think we are interested in trying to shift technological development from private to public. A different relationship, have technology social relations in a way that doesn't prioritize surveillance, suppression, and extraction. What sort of values do we discover in the course trying to struggle for something like that we could then use life looks like? I think to your second point also, I don't think that I agree with you. I don't think that any of this requires any special sort of theorization of someone kind of, like I don't believe in techno-feudalism, surveillance capitalism. These are the thing that we see right now is just a progression. Capitalism as such, right? The question is, when we talk about Silicon Valley, I mean, Silicon Valley is shorthand for venture capital, which is a specific series of tools, legal loopholes allow for well-connected libertarians to back each other and to translate speculative gains, real wealth, political power, regulate. And it's also shorthand for the relationship that Silicon Valley has, industrial complex, because advanced contracting is part of the history of technological development in the United States. The extent to which it's prioritized advertising, surveillance, electronic monitoring of dissent, protection of force abroad, electronic communication so that you can securitize assets, but also communicate quickly information. Intelligence gap. So I think it's not that trying to develop a more complicated question is like, this is an opportunity, in the ideal world, it would be an opportunity to say, one of the great destabilizing threats that's going to emerge in the next few years. And, as these speculative frontiers, I think, in the United States fail to yield the same sort of wealth that they might have in previous eras, technologies that have been developed there and the ideas that are growing increasingly reactionary supporting it, going to cannibalize larger and larger swaths of the world, really, but also ideologically. How do we insulate? How do we, destabilize that? Destabilize that question. That's my interest, because I think that, that it's through that we can then create safe spaces and experiment with What is a way beyond like a very narrow capitalist vision of tech? What is a way that we can think about identity, forming ourselves and becoming? A way that we can think about the information that we leave behind, or the information that, again, what is a way that we can think about we grow and build with one another, with the fact that we have so much of our daily life mediated, digital and algorithmic.
I mean, I'll say very quickly, the historian Maya Jasonoff, I think her project is about things like what that means when we're all told to private entity. But I think, I mean, and I think this idea of market crafts that what I have been thinking about, how financial markets operate as vehicles for the transition. And like, of course, there's this deep irony for me that what Silicon Valley has created is cryptocurrency, which pretends to be a kind of financial mechanism that never forgets. And what that entails, that we have kind of, I don't know, at some point I was like, oh, maybe our emphasis on universal recall, like this is its final form. But I don't know, I've been thinking a lot about how the tradition of oblivion, what you do see in it is the kind of recursive obliteration of debts and financial records to try to have a break and end these kinds of crises from folding themselves. And one of my subjects is this body called the Committee on the Liquidation of the Past, which was formed after World War I, which was a product of the Reparations Commission. And what they were doing is precisely trying to, it was an impossible task. They were trying to figure out how to distribute the material goods that had been confiscated and conflated together during the war. And it's a very, very mundane body, but you have this like, okay, 100 sheep go here, 200 sheep go there, and that's actually what you get. And they weren't able to finish their work, and they ended up issuing all of these bonds, which were then like kind of stored at the central bank for central banks. And those bonds were never paid, obviously, because then the Nazis came to power and obviously. So there's this really strange thing that happens in the immediate days after German reunification. In the 90s, what you have is German citizens, the World War I bonds immediately became due. And they were faced with a bill, every citizen in Europe, to kind of pay back this outstanding debt that had not been serviced in all of these years. So I think probably that will not be the last time that we.
I'm going to call it a day at this point. So thank you to all for your views. Really, really interesting.